The only way that we can have conversations that allow the passion that we want is through values. What kind of values? I'll tell you. How about civility, compassion, respect, empathy? So if you enjoy the kind of music I'm playing, which combines and balances the idea of thoughtful notes, mindful execution, and passion, I think you're at the right place.
Give these two a big hand. Judicial candidates are limited in discussing certain subjects. Would both of you guys agree with that?
Absolutely.
Yes. Okay. Now, as much as you guys want, that is for them to answer everything, they can't. And so in Canon 7, it states in part that candidates should not make pledges or promises of conduct in office other than the faithful and impartial performance of the duties of the office. They're not even allowed, in a sense, to announce their views on disputed legal or political issues. Judges must be apolitical. They are not only expected to be impartial, but also appear to be impartial. Therefore, judicial candidates must not make promises during campaigns about how they might rule or otherwise suggest that they are prejudiced one way or another on a case that they have not heard yet. They must decide cases based upon the law and the facts presented in the courtroom, not on the basis of their personal views, etc. How many of you guys are thankful for that? Some voters, however, are unaware of what I just read, and they do not understand this restriction on the ability of judicial candidates to discuss their views. And yes, judicial candidates often uncertain what they can or cannot say in response to the questions that are asked of them. And so, in a sense, this is very difficult because the candidates themselves sometimes are trying to parse in real time, should I answer this, yes or no? And so it's difficult, right? The penalties judicial candidates may suffer for making wrong choices in this context range from embarrassment to even sanctions. And so I'm going to start the questions. I'm going to start with Scott. And this would be nice if both of you answered this. Since neither one of you is considered to be a politician by function and or branding, and yet we, the people, see the signage, get the robocalls, view the television ads, and hear the stomping, then what does all of that suggest to the voter, Scott?
I think while we strive to not be politicians and we expressly eschew a lot of the political conduct, it's still an election. And there's no way to get through an election without of some of that circus that goes along with all of the elected offices. I think the point of that is to try and lay out kind of what some of the differences are and maybe why people would want to vote for one of us over the other. I encourage you to do the research. Like you said, there's not a lot we can say necessarily on some specific issues, but there are differences out there. I have more experience. I've been with the public defender's office for 17 years. We handle somewhere between 400 and 500 cases a year. So you can do the math on how many cases I've handled. But more importantly than that, and I think that the experience that I have that really is the one that makes it more important for judge, is that I've supervised attorney and support staff, about 60 attorneys and another 60 support staff across 4 counties and 6 offices. And any one time I was overseeing between 30 and 40,000 cases a year. And that's the kind of administrative oversight and administrative experience that it's going to take to run the court docket. So what is all the signage and the pop and circumstance? I mean, unfortunately, it's politicians for non-politicians.
What say you, Paul?
Well, you just saw an example of it getting politicized. So, the signs, we have to get our message out to the people. We have to get their attention in some way. So the signs, the other ways to get notoriety are, they're kind of a necessary evil. And I say evil because some of it gets that way. But if, once you get the people's attention, then you get to let them know what you're about. And I can tell you my experience is I have about 22 years of experience in the legal system here in Pensacola. In the last 7 or 8, 9 years that the clerk's office has been keeping track of cases that you're the attorney of record on. I have 1,898 cases that I have put my hands on myself and done myself, not overseen, but done by my own hand. I have another 280 in Santa Rosa County. I've got 67 trials, jury trials. Unfortunately, 16 or so of them are murder trials, which is a whole nother issue. I've got experience in civil practice. I have 4 years in a civil practice firm, and that's within the last 10 years. I myself have been at the public defender's office for 8 years, so I saw a lot of cases go through there. But I've got more experience in all those areas. Everything that Scott's done, supervising, I've put my hands on those cases and actually worked the case myself, and there's a big difference between doing that and observing some.
That's just not true, Paul. That's just absolutely not true that you have done the same number of cases. I was with the public defender's office significantly longer than you, handling significantly more cases. So you've got about 1,500 in Escambia County. I've got thousands. And let me tell you, overseeing cases does matter because we're talking about government budgets and taxpayer money. So absolutely being able to oversee cases makes a difference.
Well, I can tell you that the lawyers only move the cases so far. The judges are what move the cases. And I don't care how many thousands of hours you have sitting in a courtroom, putting your hands on the case and knowing the case from beginning to end is more significant experience.
And I have more of that experience as well.
I can also say that judges don't administer people. You may have a JA working for you. You don't have hundreds of people working for you. I've had big jobs in the military where I've supervised 125 people, 150 people on important matters like the maintenance of airplanes. So as a judge, you don't do that. You're not running the business as a judge. You're showing up and being fair to everybody that appears before you and making wise decisions.
Let's look at something for a moment. What is and I'm speaking about in general, what is your judicial philosophy, Scott?
Follow the law as it's written. I don't like judges that attempt to create law where it's not there. I think the law is spelled out. So my judicial philosophy is to follow the law as it's written.
Paul?
Follow the law, but inject common sense and fairness. Not to change the law, but within your ruling on the law, there's room for that.
Who are some of your judicial role models, and why are they your role models?
I think Judge Rourke was one of them. He was a Navy JAG officer, and very compassionate. Had a dry humor and slow to anger. And he ran a very efficient courtroom. He used to goat me a little bit. He'd say, "Mr. Hamlin, your problem is you want it to run like the Marine Corps, but it runs like the Navy." So he, but he would be one.
Okay, do judges have an obligation to improve public understanding of the courts?
I think so. Yeah. I mean, it's part of being a judge is, and you mentioned it when you were talking about Canon 7, is you have to avoid the appearance of impropriety. And that's extremely important. It's more than you have to not be, you have to not be good. You have to make sure that you don't look bad. And so, yeah, I mean, I think it's part of doing that, part of being fair, part of being a judge, part of being in the community. I mean, this is an elected position, right? Some judges are appointed, but that's not what we're doing here. We're getting elected. So we're being voted on by the people to serve the people. And, you know, so going through that, I mean, that's part of what we're doing is educating. I mean, I don't know if everybody even knows for this position that we're running for is a county court judgeship. It's almost entirely a civil division. So it's small claims cases, which are up to $1,000. Civil cases up to 30. That's going to go up to 50 in January. And all the landlord-tenant cases. That's a lot of cases. That's a lot to go through. And does the average voter have any idea that this one division handles all those cases? No. Is it great if we can help educate voters so they know that and know more about what's going on in the judicial system? Of course. But one of the problems that we've run into is that honestly, people just not that excited about the judicial race. I'm really, really excited that you're all here tonight, and for those of you that'll watch on video, because it really has been difficult to find people that are super fired up about the race. Lots of supporters and lots of fans, but not a lot of people that are super fired up about it. So I think it's difficult for a judge to get too involved in that without potentially showing one side or another, or at least implying a bias one way or the other. But to the extent that a judge can, then yeah, absolutely.
Okay, let's move.
Can I
sure.
That?
Now, let me state this for clarity. Anytime that I ask a question of Scott, you can certainly respond, and vice versa. Okay, sure. And one of the things that I want to encourage is a functional approach. From time to time, we get dysfunctional in this sense, so we don't empathize with the other person. And I'm encouraging every one of you guys here simply learn how to look through someone else's glasses beside your own. Walk in someone else's shoes, and maybe we can understand why a person is answering X as they are, or whatever. And so I'm for civility. I'm for competence. I would rather see a competence hierarchy here and that kind of conversation here than I would a dominance hierarchy, or we have two bulls fighting and one bull beats the other bull and the rest of us just follow out of herd instinct. That's what I'm trying to avoid, and I think both of you guys get that, but you wanted to say something.
Yeah, what I wanted to add in the importance of educating the public on the court system is so that the public understands what goes on in the court and accepts it. You know, when you don't know what's going on, you tend to be critical. You don't have a full explanation of things. You tend to doubt how did the system work, or people walking out of court going, well, that didn't work out too well. So if they understand the system, they may understand why things happened, and it gets them on board with the court system. As a society, we need to have these rules that we all agree to live by. And so if you have people that are not informed on them, then they can become outliers, and that causes a problem.
Scott, if you observed a party in your courtroom being poorly represented by an unprepared or ineffective lawyer, how would you handle that situation?
This is a fantastic question. And it's probably not the answer that you expect. The truth is you do nothing. And you have to do nothing as a judge. And the reason is because there are appellate and post-conviction proceedings to deal with that. But at the trial court level, for the judge that's on the case, the parties have to make the objection. The problem's got to be pointed out. Judge can't insert themselves into the process. No matter what you may feel about it, you may feel terrible for let's say it's a criminal defendant that's getting ineffective counsel, but at the end of the day, you can't get involved. There are other legal processes for that have to go through.
Did you want to respond to that?
No, generally judges can't get in the middle of things. There are post-conviction in the case of a criminal and appeals that can be taken. You have perhaps, when you sentence someone, you may have a discretion. So perhaps some of that, what you've heard during the trial and how the person was represented, can be woven into the conclusion of it. But generally, you can't get involved, even if they're getting their brains beat out. Or somebody doesn't know what they're doing. It's just the way it goes.
Paul, do you foresee that is any problems moving from your role as an advocate to a judge?
No. A judge has got to be fair. If those things affect you, still, I'm a defense attorney, of course, criminal defense attorney, among other things in the past. But you're advocating for that person. But you can, as lawyers, we do it on both sides. I mean, you could take the defense attorneys and give them prosecutor jobs, and that happens all the time. So we're able to switch roles, and in the role of a judge, obviously you're neutral, and we can do that.
Quite the opposite. I'm actually really looking forward to the change in perspective. I tell people being a lawyer is what I do, not who I am. And I think when you're looking at this kind of a switch, there's a Supreme Court justice that said it, I think, as well as I can. I've been in a courtroom, I've thrown the ball, I've swung the bat. I want to call balls and strikes.
Okay. How many of you guys are enjoying this discussion? How many of you guys believe that it's civil? I do. And so let's keep moving the ball forward a bit because do you think the court system is working, Scott? Or do you believe the civil or criminal justice system is breaking down a bit?
It is the absolute worst system in the world, except all the others. So, So
in juxtaposition, you're saying all others are much worse, but you're saying that ours is failing, correct?
Ours needs a lot of work. There is definitely a resource drain on the court system. There's a case backlog on the court system. You may be surprised to learn COVID didn't back things up as much as everybody kind of expected it to, so that's a good thing. But the civil docket is still pretty backed up. So is it broken? We have a lot of things that need a lot of attention. Juvenile crime and how juvenile offenders are treated is a major issue. Sentencing disparity is still a major issue that nobody's cracked. Pretrial detention and pretrial bonds are a major issue. So does it work? I don't think it's a total failure, but there's a lot of room for improvement.
Give me a suggestion. What would you get at if you had the power?
So my main thing is efficiency. Courts are crowded. There's a lot of people in there. There's a lot of business to get done, but you've still got to spend the time with everybody. So every minute I can take out of an unnecessary moment where things aren't getting done, I'm moving a case, I'm getting someone their day in court. And that's really what it's about. County court's often called the people's court, and it's because it's small claims, it's lawsuits under $30,000, it's landlord tenant. It's important that the people know that they're going to get their time in front of the judge. And so, cutting back the efficiency or increasing the efficiency, certainly one thing that I think is important. Having just the kind of experience to know what the clients are facing and what the people out there in front of the judge is facing. I tell, you were talking about looking at it from somebody else's eyes, and one of the things that I used to teach the attorneys that I supervise and mentor is every once in a while, just get up out of your chair, walk around and sit on the other side of your desk and look back and see what your side looks like from the other person's perspective. Just a reminder that it's not always from your side of the seat. Understanding that makes it better. I think a lot of judges try, but I think it's difficult to do well.
If I can question something that you said about efficiency, Dr. Eagleman, he's a cognitive scientist. He states that our brains are an efficiency organ, not an accuracy organ, and that's why we wind up making all kinds of mistakes because heuristically we're hardwired to have go-tos. And in that sense, or in that analogy, would it not be true that if you ran this thing more efficiently or efficiency was the main theme, it would function more like the brain and do away with the accuracy of the court and the practice of law.
Fair question. No. The short reason is it's more efficient to multiply 99 times 89 with a calculator, and that actually still gets you the better answer. So if I can make something more efficient in the courtroom, if I can make it so that people aren't standing over in the corner not calling a case, I can get the case called, right? I can call the case. That efficiency is making accuracy because that's time I can actually spend on the case. But
most of the complaints that I hear about people who go to court, they were never given the time that is to tell the truth, the whole truth, and nothing but the truth, because lawyers are actually trying to make it more efficient, trying to get their way, persuade left or right. And so that really has me troubled, to be honest with you. I can see part of it, that is the efficiency argument, but I also see that if you negate the accuracy, that is of how law should be served, because let's say that you're trying to get at the intent of someone, that may require much more time than what we're spending right now. Let's move on. What say you about all this?
To me, the most important thing is get it right. You know, we can pump cases through. Hey, you call a case, get up here, do that, but we got to get it right, or it's either it's going to come back, you know, because it's improperly handled on an appeal, or the people that are involved in it don't feel like they get their day in court and that it was done right. I talked to all kinds of people, you know, that they say, well, you know, that I was going through a child custody issue and the judge didn't even pay any attention to what I did on this, and this thing is all messed up, it's not right. Getting it right, I think, ultimately makes it a better and more efficient system.
How do you deal with difficult people, including peers, lawyers, clients, and litigants?
We have agreeable clients. Yeah, the clients that we have, especially at the public defender's office, where we've both been, where you handle a lot of people coming through, it's tough. What I try to do is treat the 10th person like they were the first person, and don't let 9 people's, your frustration with the 9 prior, it was my cousin, I didn't do it, you're not helping me. You know, don't put that. Don't handle the 10th person with that cumulative amount. Have a fresh start with every person, client, whoever.
Did you want to respond to that?
Yeah, I mean, mine's pretty easy. I mean, Paul and I agree on this. We've both dealt with very difficult clients. We've both dealt with difficult judges, and we've both dealt with difficult opposing counsel. But I just always fall back on what I was born and raised to believe. Be fair and treat people the way you want to be treated. And even in a courtroom, even with somebody that's calling you every name in the book, saying everything they can, you can still take a deep breath and still treat them professionally and respectfully, and that's all you can do. They're going to do what they're going to do, but you have to behave yourself appropriately.
That's good. Scott, would you be so kind as to describe a situation in which you took a controversial position that angered or offended people, and explain how you handled it?
Well, sure. I've gotten death threats for cases that I've handled before. So is it really a controversial position? I guess. I mean, people don't like you defending people that are charged with murder. And I've had a couple in particular that were murder cases that involved insanity, and voters, citizens, jurors are particularly leery of insanity defenses. So, trying those cases, you do get a lot of negative feedback, and you do get a lot of, how can you do this? And, what are you thinking? You deal with it because it's the job. That's what I signed up to do. I believe everybody deserves a right to a fair trial and to have proper representation to get to that point. These were horrendous, terrible, tragic crimes that you probably know if I talked about them. But at the same time, that's what our system is about. It goes back to, the very beginning with John Adams defending the British soldiers. I mean, it's a very founding principle of our country. So,
Okay, Paul, if you were the person responsible for deciding what cases would be tried in what order, how would you split the court's time between the criminal calendar and the civil calendar?
Well, if someone's in jail, first of all, the criminal involves people in jail. you want to resolve those first because they're sitting in jail and they're innocent until proven guilty. So they're in jail, not yet convicted of anything. So you would try to handle those first. Then somewhere in, the civil docket is important because that's people's livelihoods. It's monetary issues, which sometimes is taken more serious than serious criminal cases. So you'd have to find a way to feather that in with the remaining criminal cases of people that were out of jail. You'd have to find some way so it wasn't just whimsical and so that it wasn't arbitrary, because you can imagine all the people in line saying, wait a minute, where's my trial? So maybe, you'd have to determine some level of importance or length there, but primarily get the criminal in jail people resolved first.
I think it's pretty straightforward. The law is very clear that criminal cases take priority over civil cases, so that's the order.
What is law?
I don't know if I can answer that as a philosophical question. If I was answering in a legal brief, I'd go to Black's Law Dictionary. It's the rules that we've all agreed to follow.
Is that it?
That's all I'm saying on that.
Okay. I really want you to drill down a bit, because I think that we the people, we need to hear from people who have been in law a long time. When we get a good understanding of what the law is, because I can make the argument without codification, our species would not have survived. That's very important. Codification is something that we need to respect. Law enforcement, that is, everything that's been codified, whether you agree with the code or not, it's very important to our species. And that's why this conversation is very, very important, because we're not just looking at two people who are lawyers, but we may be looking at the next judge, right? That sits on the bench, and they will be determining many, many different things. And I would like to ask some questions, but most of my questions, honestly, that I wanted to ask you this evening, I know that you couldn't give me an answer, so I didn't want to set you up. Yeah. And so,
sometimes it's fun to watch us tap dance around and try to answer without answering.
Some people tap dance and they don't even know what they're dancing to, right?
Right.
Thank you. So, Paul, what is law? I mean, this is a term that, everyone here, they hear this all the time, but in law school, there is this determinate nomenclature, and you guys understand law possibly in a different way than, let's say, the average Billy Bob walking down the road, correct?
Law, isn't that a TV show, Law and something? But, in law school, we don't get a lot of behavioral science, psychology type training, to be able to determine how people are thinking, a modality for, are people lying on the stand, things like that. So, we kind of pick that up as we go through our cases, maybe not even knowing that we're getting it at the time. So law, I think, it seeps into society from the beginning of agreements that we made with our neighboring tribes. That was the beginning of these ideas that weren't necessarily written down, but were somehow things that we all understand. As society progressed, obviously we need things written and that they have to go by, but a law is not just the writing, it's the perception that the reader has or the citizen has of the behavior that's acceptable, and what amount of freedom are we willing to give up to follow that so-called law.
When people go to court, they hear this when they sit on the stand, and correct me if I'm wrong. Do you swear to tell the truth, right? And so on and so on. So truth is a big thing, right? And so I'm going to ask you what your understanding of truth is, because I think that's very important that we, the people, understand your view of truth, because when you look at truth, not just in philosophy, but in other fields of discipline. We have the correspondence theory of truth. We have the deflationary theory of truth. We have the coherence theory of truth. And I could go on and on and on and on. And so which theory makes more sense to you than not?
in a courtroom, truth is what can be proven by fact. So that's truth. It's something that can be objectively proven.
What say you?
Well, truth, there's not one absolute what truth is. Truth is your version of what you may think occurred. It says people are testifying. We all see things in a different light, and we all have different backgrounds and experience that tell us what the facts of a certain thing are. And is it true? Is it true that these lights are blue? Well, yes, but there's white lights too. And what is blue? I mean, you can go in circles with yourself on what is truth. Ultimately, truth is what the jury says is truth. They're provided with the facts, and they determine what the outcomes be, and if someone is testifying, their perception of the jury's perception or the judge's perception of who's telling the truth, that becomes the truth.
The reason that I ask about truth, and you brought up objective, if I go to the correspondence theory of truth, it simply states, and most people would agree with this, who make the argument that that would be the position to take, that which comports to reality is truth. And that's why a lot of people are trying to make the argument concerning facts. But I would say that which comports to our interpretation of reality, because it's an interpretive process. So how objective are human beings?
So, yeah, I mean, I think I understand the point of that question. And, individually not very good at all. But, it's interesting with juries, when you put them together, they tend to get it right. For the most part, they tend to get it right. So in math, I think, maybe okay at it, individually, not so much.
Do you have a response to that?
Well, the collaborative method of arriving at the truth would be the jury. Otherwise, you have peer pressure. People try to persuade you of the truth. Just people's generally observations of things. You can observe the body, the posture and things of people. Does it agree with other evidence that is presented to you? Does it seem reasonable? All those things help you determine the truth as a judge.
Let me put my position on the table as if it matters. I have a perspective of truth, not truth itself. And so I can work with the theories, but I'm simply working with the theories. Does that make sense to you?
Sure.
Okay. And so, how about you, Paul?
Yes.
Okay. So we have two people up here who are working with a system. How many of you guys can see how both of them are very disciplined, right? And so I want to end with this. I'm multi-axial, and what that means is I don't think that everything rests upon a single axis of thought, right? So you're making an argument, or someone's making an argument in court. How many people are going to give enough time and bring in, all of the people that would really get at what axis of thought that a person is suggesting, that is, if they're on the stand?
Okay, ask me that one more time. I want to make sure I got you on that.
Okay. If I'm multi-axial, it simply means it's a 50-cent way of saying I don't think that everything rests upon a single axis of thought. Let's say that you have a particular person who's sitting on the stand, and they may be using language in a way that suggests that the axis of thought that they're dealing with is A, and then the lawyer over here is equivocating, right, and trying to change that or twist that into something else. How can you make sure that is, as a lawyer or even a judge, that everyone stays on the same axis of thought so people are not equivocating in the courtroom? Because that is what happens all the time. Equivocation.
It does, and I'll tell you, that's a tough answer, and the reason is the system's almost designed for that.
Designed for equivocation?
You're talking about having someone on the stand and then the attorney and them not being on the same axis of thought. Well, a lot of times the attorney's doing that intentionally to try to trip up the witness. So there is a little bit of that that's just systemic. It's just part of the adversarial nature of the process, unfortunately. And there's not much you can do about that. And as a judge, all you can do is hold it to being respectful, not antagonistic, and is civil, I guess, to use the word that you've used many times tonight, as you can possibly make it within an adversarial system in a courtroom. I mean, it's, you hope that you can walk out of there as an attorney and you don't take it personal, but sometimes it's pretty knock down, drag out in a courtroom, and sometimes that is specifically a strategy.
Paul,
this is going to shock you, but in a trial, we're not trying to figure out what happened. We're trying to come to the state attorney. It's criminal, civil's different, but is trying to prove beyond a reasonable doubt to the jury that the elements of that particular crime that the person is charged with were met. And the truth gets lost in that. It's what can be proven, what evidence comes in, what evidence is excluded. It's on your scale of truths, that's a pretty significant thing. But we are not necessarily trying to get to the truth. The state is trying to prove what they can prove, and we're trying, as a defense attorney, to prevent them from proving that. But the focus isn't figuring it out. That sounds a little unreal, but that's what happens.
in conclusion to our discussion here, hopefully you guys are enjoying this. What's your best joke, lawyer joke?
Mirror, right? I mean, lawyers are the joke by themselves, right? No, I mean, the best one I can do is I did go to a Halloween costume party in law school with nothing but a suit, a copy of the Constitution, and some blood on my chin as a blood-sucking lawyer.
What I usually say when people tell me a lawyer joke, I say, next time you're in trouble, call a comedian. See how that works for you.
Give these two a big hand. And hopefully I can get these guys to shake my hand and hug me.
You a hug. You hugged the last group.
Yeah. And hug each other. I mean, we want to be civil and good. Come hug my neck. Let's stay committed to a process, not the conclusion. Let's better ourselves. How many of you guys can see that we need to better our conversations, better our behavior? I can say amen to that. And so you guys really did a great job tonight. And so thank you so much for coming.
Methodology means a lot to me. The journey is what it's about. In other words, exploring things on more than one axis. And this is the reason that I keep talking about being multi-axial, because in being multi-axial, one has the advantages, yes, of different vantage points. If we were to look at, let's say, the people who framed the Constitution, the people who put together this country, it's a civil experiment. In doing so, they put together a balance of power. This is so typical when you're multi-axial. You don't want to look at things through just one lens. You have to look past the surface structure, look into the deep structure, and try to tease out what's there.